Hello, my name is Ryan Green, and welcome to the Last Splash podcast. My guest today is Pete Salsich. Pete is a entertainment and intellectual property attorney at Cape Sokol, a law firm based in St. Louis. He was previously the in-house counsel at Cool Fire Studios and is currently an adjunct assistant professor of law at his alma mater, St. Louis University Law School. He is also the host of the Screen Lawyer podcast, which I was a guest on, and
Yeah,
now
that's right.
Pete is a guest on my show. So welcome to the show.
Thanks, Ryan. Good to be here.
For our audience, can you describe what falls under entertainment and media law in your perspective? How much of what you do focuses specifically on copyright? Is that the right way to think of you, as the copyright guy, or would you say that your focus is broader than that?
It's probably broader than that, but copyright is at the heart of pretty much all of this work. I mean, the way I think of my practice really is if something ends up on a screen, then we do the work. I've done the work to put the business together, raise the money for that, acquire the rights to that, make sure all the contracts for all the contributors are proper so that the production company ends up owning the copyright. And then if there's a distribution, then that all is based on typically the ability to put something on a screen and then make money off of it or reach the audience you want, whatever your goal is. Typically, often depends on there being one copyright owner so that you can control where it goes, make sure it doesn't go places it's not intended. If there's revenues to be generated, that you are the right recipient. You may have to pay other people along the way that you've made promises to, but the point is that all flows from there being one copyright owner. And so then as you're putting together whatever it is, it's going to end up on screen. Whether it's film, television show, could be videos for corporations, could be brands, could be YouTube channels, literally anything. The contributors to that, you've got to capture their copyrights into one whole in order to actually have success with it. And so copyright is kind of at the heart of everything. It's involved in all of the contracts that we do. It controls the licensing. So yes, copyright is very much at the heart of what we do. But I think my practice includes the business side of things getting onto a screen. So it's a little bit broader than just the copyright part of it.
So when you are looking at the business side of things, especially my audience is a lot of agency people and a lot of marketers, how do you advise, in particular as businesses are starting, what to be thinking about to safeguard their media, entertainment, marketing businesses from potential litigation down the line?
Great question. And I think it's really key to understand the basics of copyright law, how that works. And then there's not just copyrights, it's also the rights of the people who are going to appear on screen and possibly brand logos. Then there's also issues with your messaging. Are you saying things that are true? So there's a number of layers. And so in the advertising world, in the brand world, that everybody's using video these days. Not a lot of businesses come at it from a production background where they sort of understand these things at their base. A brand who's hiring a digital agency, for example, there has to be a determination. Does the brand want to own the copyright in those video products and control where it goes? Or is it allowing the production company, for example, to retain the copyright, but getting permissions to air it? Some of that may depend on who's in the film or who's in the thing. If you're doing a commercial, for example, I'm going to use the word commercial, thinking in terms of sort of what we grew up watching on television that interrupted our programming, but same sort of thing, branded video, branded content. If you have particular actors who are, performing in those videos, their contract may have a term of use. They may say, yeah, you pay me this much, you can show this for a year. If you want to show it for another year, or you want to take it from your social media platforms and put it on to production, a broadcast production or something like that, or on a billboard or someplace else, well, there may be negotiations for all these different types of uses. And so just having the copyright may not give you all the rights you need to do those next things. So you kind of have to look into what is the intended use of the video, where it's going to live, And then who are the people involved? And if the brand really wants to control and make this evergreen, we can use it forever. Well, then they're going to have to make sure that that language is in not only the contract they have with the agency or the production partner, but if the production partner is going out into the world and getting the talent, getting the crew, sourcing the music, for example, or other things, they've got to make sure that they get the necessary rights from those third party contributors so that they can give the brand what the brand is expecting. So I think if you're from the brand's perspective, you need to have some understanding of what the agency should be doing. And if you're the agency, you need to have a clear understanding of what the brand is expecting, and then make sure you have the understanding of how to make sure those rights are there. You may have independent contractors that you're using for various shoots. They're not your full-time employees. We've got to make sure that every single time those people show up at a project, that there's a crew deal memo that captures that the results and proceeds of their work on this production are a work for hire, maybe for the agency, maybe for the brand, maybe both, one way or another, first to the agency so the agency can give it to the brand, to make sure that the brand is getting what it's paying for, right? And so having an understanding of how that all works, I think, is key. And that's typically where we spend a lot of time early on in a relationship with an agency or somebody kind of new getting into this space. A lot of times it's brands, first time they've had to do this, and they don't really know hey, this agency gave us a contract. Is this the right kind of contract? That kind of thing. So, depending on who I'm talking to, the education may be a little bit different, but it's real important to understand how copyright works so that you can draft the contracts correctly to achieve whatever your goal is.
And that gets really complicated. If you have the brand who then has a full service agency and then maybe contracts to a production company who then is sourcing talent, right. I'm sure there's some indemnification that may need to happen in some of those contracts. If you're not able to see the sub contract right. as the brand on the top there, it's opaque. And that has to be a challenge, I would think, about what your primary contract looks like to make sure that it waterfalls and protects.
You literally, that's exactly right. And that's the key. And it is a waterfall. And so you do have to, the first conversation is typically probably with the brand and its, agency of record, if it's that role, or the primary agency that's putting together the whole campaign. What is who's the intended owner of this particular output, these videos, this campaign, whatever it is? Where is it going to go on digital television? Is it going to go on social media only? Is it going to have a YouTube channel? Wherever it's going to live, right? Those two mm-hmm. things are key. Obviously, budgets and all that stuff are part of the business anyway. But those two questions, where is it going to live, and what is the brand's expectation of its rights with it later? Once those two things are figured out, then that should be in the contract between the agency and the brand for that project. Then the agency simply has to make sure that as it turns, like you said, down to maybe the subcontracted production company, the agreement between the two of them matches those same terms, whatever those are. And then the production company's got to turn around and make sure that the talent, it's independent contractor, crew personnel, editing suite, if they're licensing music, that they have the right, mm-hmm. The license from the sync licensing music. The prices all depend on where this is going to live. Social media has probably got one cost. Broadcast has another cost, those sorts of things. So it very much is each person who's receiving the job has to turn around and, make sure those same things flow down. And if there's a break in the process, yes. And each one of those contracts probably has a representation and warranty. So the agency's making a rep and warranty the brand. All the rights that we're saying we're giving to you, we will ensure that we get all those rights. And mm-hmm. if you get sued because someone says we didn't get the rights, that's on us. We'll indemnify you. They turn around, the contract they have with their video production contractor should have the indemnification that the video production contractor says. All of the rights we're giving, we have the right to give them. We will get all the clearances from crew. We will get all the clearances from talent. We will get all the clearances from music to give you what you're in. And if you get sued or your client gets sued, the indemnification flows up. The challenge is you push that indemnification all the way down to somebody that probably doesn't have any money to pay for it. So,
That's right. Yeah.
but that's why if you're in the industry, each one of those players should have appropriate liability, errors and omissions, production liability insurance
Hmm.
to cover the process. And when you get that insurance, when you fill out your application for that insurance, there's a whole section that says, you say, I will always make sure I get all clearances, I obtain all rights, et cetera, et cetera. Because if you don't, then your insurance company is going to deny coverage because you lied on your application. Right. So the
Yeah.
process of being a pro in this, getting that insurance to understand that kind of helps, I think, sometimes people realize, I better make sure I do this correctly every time.
Yeah, I wonder how many, especially to the consultants and freelancers who listen to my podcast. I wonder how many have the appropriate E&O insurance. That was only something that came into my purview probably in year 8 or 9 at
Yeah.
my agency, where I even knew that was something to start looking at in contracts.
Yeah.
So that's certainly something. Look up air and emissions insurance, and a couple of the others if you are in the middle of some of these indemnification disputes. You don't want to,
Right. Yeah.
be
And
caught with your pants down, so to speak.
it's particular, it's the types of policies for people in the production world are unique
Hmm.
to the production world. There's specialized policies. As a lawyer, we've got professional liability insurance. We've got our version of that, but it doesn't cover a claim of copyright infringement because we're not in the business of dealing with copyrights and using, you know what I mean? It covers the things that are relevant to our profession. So that's why somebody said, well, we've got our standard, we got workers' comp, we got some standard business, commercial general liability policy in case someone slips and falls in our premises or whatever. Like, yeah, that's great, but that's not what we're talking about. We're talking about an additional level of a professional liability policy for people in the production world, entertainment production world, video production world. And those policies are written specifically to deal with a copyright infringement claim. In fact, most commercial general liability policies for businesses expressly include what they call advertising injury. And that's copyright
Yep.
infringement, trademark infringement, all those things. So if you don't have advertising injury coverage, you might be signing indemnifications all the time. You're just, sure, sign the contract, not realizing, hey, if we screw this up, we're on the hook.
Advertising injury is not just getting hit with 1,000 ads from the same company once a week. It's
No,
a
that's a different
legitimate legal term.
That's a different kind of advertising injury. That's pretty funny.
Let's go back to music a little bit. I think there's a lot of brands that are involved with social that want to share content that
Yeah.
one of their customers may tag them in and want to celebrate. Right? It's just a really quick thing. Is there liability that as brands start to share UGC content or that are really involved with influencers, that they should be thinking about as they're either using those assets or as they're starting to build more and more long-term contracts? I know you started to talk a little bit about the length of use, right? If that's
Right.
going to be used, if
Right.
something's used in perpetuity or not,
Right.
as it pertains to social and influencers. Without giving away your hourly rate,
No,
obviously,
that's right.
what's some top-level advice that
Well,
you could give to brands?
yeah, great question. And obviously that's a huge thing these days, right? Influencers are advertisers. And social media influencers, the use of influencers on any kind of social media, it can be a quick clip, it could be a reel, TikTok, doesn't matter what it is a commercial. And it's governed by the Federal Trade Commission, the FTC. They have guidelines about truth in advertising. Taylor Swift, let's say, does a TikTok about new shoes she loves. If she just went into the store by herself and bought those shoes all by herself and says, I love them, well, great, lucky brand. But if she got the shoes for free or there was any kind of consideration involved whatsoever to that deal, there has to be something in her post that indicates this is an advertisement, And so you see things hashtag ad, hashtag sponsored. There has to be a disclosure in the context of the video itself, show notes in addition, whatever, that this is sponsored content. This is not just somebody's opinion. This is, in fact, a commercial. And so those rules apply. So we deal with social media influencer agreements all the time, sometimes for the influencers, sometimes for the brands, sometimes for the agency. But they're literally just like hiring any other spokesperson. What's evolved, right, is it used to be you'd hire in St. Louis, if you grew up watching baseball, you see Ozzie Smith would be coming to talk about a window and door company, right? Well,
Yep.
the company or their advertising agency, however it was put together, they paid Ozzie Smith to do that. And then Ozzie's, name, likeness, image, identity, personality, whatever is worth X number of dollars, and he gets paid for those things. A social media influencer doing a 20-second post or a simple verbal post only or a short reel is the same thing. It's exactly the same thing legally. So you need to make sure that those rights are in there. And included in there, of course, sometimes will be an obligation. The influencer agrees to post, 3 times a month on these 3 platforms or whatever. Well, there's a contractual obligation. Did they do it? Have they earned the right to pay? Sometimes influencers say, I don't want my thing to be used in connection with anything that are, certain types of industries or certain types of brands. I don't want to be associated with smoking or pornography or whatever.
And exclusivity too.
Sure. Well, exactly. Brands may say, I don't want you also, shopping this other shoe or whatever else. And so all of those things are negotiated and should be in a written contract. Agencies who maybe have relationships with a variety of different influencers and occasionally will match up an influencer with a brand need to understand with their influencers, do the influencers have any particular, I won't go here, or I won't go there. Those things need to be, worked out in that environment. It's a huge evolution, obviously, to brands getting their message out, but essentially it's not new, right? It's still just the commercial with the same rules. Copyright law applies the same way. You got to get the rights. If the influencer is holding the camera up as a selfie and doing it themselves, they own the copyright in that video when they take it. So they need to assign the copyright to that video, or maybe they aren't assigning the copyright. They're just licensing it. Or maybe they're just posting it on their own social and the brand gets the right to share it or repost it. All of that stuff it should be in a written agreement. The brand wants to effectively tag itself into the conversation. It loves, it sees a video, it loves the music and thinks, oh, I want to share this as if we're somehow associated. Brands need to be careful about that because you and I as individuals, we see something on, Facebook or Twitter or TikTok or Instagram or wherever, there's the platform's rules tell us what we can and can't do, what we can share, those sorts of things. But those are all just personal use rights. The moment a brand takes some content that it saw on a social media platform and uses it to sell a product in some way, those terms and conditions don't apply. You're back into the world of, I have to pay for that. I have to get permission for that. And so sometimes people think, oh, well, I do this at home all the time on my own Instagram. I'll just start doing this for the brand. That could be risky. Right. Yeah. And you can get hit. And, next thing you know, your brand's, you make all your money on your Facebook page. And all of a sudden your Facebook page is down because of a copyright strike. And now you have to fight over that, but people can't find you. That could be devastating.
Is there a length of time that a brand could use a video or audio clip that is within fair use, right?
Another great question, because it's a common thought and it's not accurate. No, there's no such thing as like you tell your kids that they drop food on the floor, 3-second rule or whatever, you pick it up. Yeah. There's no such thing in this space, right? But people think there is a lot. And the reason for that is under fair use. So for people who don't know, or for a quick little primer, I could spend a week talking about fair use. We don't want to do that. But basically, fair use is a doctrine that says, I can use somebody else's copyrighted work in certain ways without their permission and without being guilty of infringement if it qualifies as fair use. And so the courts would weigh certain factors. What is my new use going to be? What is their original use? Am I transforming it in some way? One of the factors is, did I only use as little of the original as necessary to make my point? And so that's the thing that people go, oh, well, if I only use 10 seconds of the thing, then it doesn't matter.
Mm-hmm.
No, that's just one of four factors that gets made. But if it's not, if you're using it in a commercial, it's not fair use, period. It'll
Mm-hmm.
automatically not be fair use, pretty much.
So if you're putting money behind it, right? Is that what you're saying?
It's not necessarily putting money behind it, because for example, I can make a documentary, right? And my documentary, there's in the documentary space, there may be a lot of things, and I can use clips of other footage to put together to tell my story. I want to show old news footage. I want to show some other things, and together I'm going to tell this larger story. Well, I may be able to, because of the nature of my use of the documentary, and I'm only using these clips, and I'm transforming it and putting them in a different way to tell a different story, that may qualify as fair use. But I can still put money behind that to get that into the world, and I can make money on my documentary. Yeah. That's not the issue. Is my use, because my use is to entertain, or that's the purpose of my documentary, or to educate, right? Or something like that. When my use is to sell a product, that's the issue. It's the use. What is the purpose of the new use? If the purpose of the new use is to sell a product, promote a business, promote a cause, promote a religion, promote a political campaign, any of those sort of promotional works, that's not fair use. You have to pay for that, because you're effectively using someone else's work to sell yourself or your business or your brand. That's the issue. It's not that money is made or money is spent. It's what is the purpose of the use. And if the purpose of the use is promotional, it's not going to be fair use. You have to get a license. You have to get, for every second of footage, every second of music, every person that appears, you need to acquire the rights to do that.
So then it's how you define what is promotional then. Like, let's say the Last Splash LLC here has a podcast.
Right.
And in the background of Pete's screen here is a nice cartoon that you have. I am a consultant. I would love to garner business, I suppose, from this podcast. Not that maybe the primary purpose, sure. Right? Does the artist of the cartoon behind you have a right to sue me?
Well, no, because you're not using those works as such. They happen to be where I am. This is an informational thing. You don't have control over my set. These are individual pieces of works that I have the right to physically display, and you're just seeing them as they appear in my thing. If you lifted that image out by itself
and put it on here
and put it on there, right, or something else, now we have a different conversation. Yes. Is the purpose of your podcast to help promote your business? Certainly, to some extent. It's also to educate. It's also to inform. It's also to be contributing to the knowledge base of people in your world. So it's got some...
It has mixed use, which I think a lot of people have mixed use, I want to say, because what's promotional, what's not. Isn't advertising basically trying to make things seem like they're not promotional when they are?
But see, yes, but that's when you get right down to it, it's still advertising, right? And I think, if you find, what I typically find, if somebody's trying to convince me that they're not using something promotionally, they probably are using promotionally. They just don't really want to admit it. And the point is, legally, that's going to be promotional. I mean, I realize I'm using some, there's always gray area, right? The lawyers exist because there's gray area. But generally speaking, any type of promotional use would be considered commercial. And all of this is based on sort of the First Amendment to the Constitution that protects free speech. It effectively, under certain circumstances, the First Amendment trumps the Copyright Act. That's really at its core what's going on legally. And so in the First Amendment, there's deep bodies of law that differentiates between commercial speech and non-commercial speech. So, even though the goal of great branded content is to not make it feel like it's advertising, it still is.
It's
It's
advertising, yes.
advertising. It may be very effective and terrific, but at its core, its purpose is still to promote something. If promoting it tricks the audience, that's good for the audience. That's good for everybody. But the purpose behind it was, in fact, to trick the audience into buying something or whatever. So that's how it, or voting or contributing or donating or
Sure.
whatever that.
So let's change gears a little bit and talk about data and privacy.
Sure.
We have a number of frameworks that have came up in the last couple of years that have a lot of momentum behind them. GDPR in Europe.
Yep.
And CCPA in the United States, and about 18 other states that have very similar but slightly different laws as it pertains to data and privacy. How are you advising your clients when they're both working with their existing data sets on how they can or can't leverage that data, and then how are you advising them on how to appropriately collect new data moving forward?
A very evolving area, as you said, and I think it's very easy to see that the trend is moving towards more protections of privacy rather than less, and more, significant penalties for people that violate that. Anytime you have a legal structure that is placing bigger obligations and more risky, expensive obligations on parties in this way, what ends up happening is ancillary businesses get developed to help companies avoid that. So you see more robust software programs, more robust security measures, multi-factor authentication for almost everything now. Any darn suit. I got to get on my authenticator button and I got to press 2 numbers on my phone before I can get in here. But that's because the industries react to provide products to the brands to help protect the privacy, because that's becoming more and more important. So one, I would say, depending on the nature of what business you're in, what information we're talking about, you may have greater obligations than others. But at a minimum, you've got to make sure that any personally identifiable information, monetary information, if you're taking credit cards, things like that, certainly if you're in the healthcare world at all, you're governed by HIPAA. All of these things have particular requirements. And so you need to understand what type of information you're going to possibly interact with. And then you have to have policies in place to make sure that it's safe. Everybody's moving. Amazon Web Services or Microsoft Azure and all, software. Everybody's doing things inside these cloud environments, partly because those cloud environments are putting, because they're massive, their whole big part of their sales, their pitch is, we've got the privacy infrastructure in place so you don't have to spend all the money to build it. So there's certain tools like that. If you're taking money, use Stripe or use some other third-party system that itself actually keeps the information, and you don't set to that. And then lastly, if you're taking information, let's say you have newsletters or people are signing up, certain other factors that are going on, then have a privacy policy. And so a lot of times, the biggest thing about privacy is you have to tell people what information you're taking. So yeah, log on to your site, sign up, become a member. Well, what information am I putting in there in order to do that? I've got to let you know what it is I'm taking. I've got to have a policy that says, if you decide later that you want me to forget you, I have a way for that to happen. Mm-hmm. If I'm going to use your information and sell it to third-party marketers as demographics, either with your identity or de-identified, I've got to tell you that. Doesn't mean I can't do it. I just have to tell you that's what I'm doing. Then you get to decide whether you want to give me your information. So where the privacy things are shifting is it's more about keeping control of the information in the hands of the person. And particularly, sort of, if you think about it, it's the right to be forgotten. It's the right to change your mind. Is there some way to take me out, to destroy my information? Even if I told you before it was okay. That's one of the big shifts in these laws. So I advise clients, if you're in a state where you don't have this new privacy regime, use it anyway. Use the most restricted privacy regime, because you're going to get there. And if you're on the internet, you're not only operating in your state anyway. err on the side, learn about privacy laws. We work with clients on it. There's lots of great resources, but take them seriously.
Are there any implied consent as it pertains to certain PII? Like, let's say you're a retailer and you're asking for an email address to send a receipt after a purchase, or maybe their shipping address to send them an item. Is there an implied consent that can be contacted for marketing purposes,
Well,
or not?
typically, no, there's not necessarily. So what you'll see when you go, particularly if it's the first time you're setting up, log on, I'm going to buy something for the first time from a new vendor, right? And I've got to put in my address and an email to get the confirmation and all these things. Typically, there's a box, and a lot of times the brand will have it pre-checked, so I have to uncheck it. But it says, send me marketing materials. Follow up with this, and I have to uncheck it if I don't want to get all these things. I'm not giving you this. But if you go on a new site and first time you're there, I was looking for this happened to me yesterday. I was looking for a new flag. I always have had a St. Louis flag flying in front of my house, and the one I've got just tattered and beat up. And I'm like, I want something a little bit.
You need that fleur de lis out there proudly.
100%, 100%. So I'm like, maybe I should like actually look for a better sewn, whatever. So I search flags, and of course you get a bunch of things. Well, you click on, I couldn't get past anybody's site without something popping up asking me if I want to get a 10% discount by putting in my text and my email so that I can get marketing materials. I had the option to say no, and then they don't do it. But there's a point in time where they're asking me, and I have to say yes. And if I say yes, then I've said yes. And I can, but they typically, if they're going to use text advertising, email advertising, things like that, even if I've said yes, there has to be my ability to say unsubscribe. There has to be my ability to say stop, right? And so the requirement, even for marketers that use this tool, you have to give people the ability to say stop. That's at the heart of this thing. Typically, it's putting back in the hands of the consumer the ability to make the choice every time.
Another area I wanted to talk about was artificial intelligence. We met when I was hosting a panel on AI earlier this year, and I think you had a couple of really interesting questions and points during that discussion. How has the case law evolved, or has it even been adjudicated at all? Is there any precedent that we can talk about as it pertains to AI and content and copyright?
Not yet. There's a lot of lawsuits, but we don't have any decisions yet. In fact, I've had 3 or 4 episodes on my podcast talking about the latest lawsuit filed. Most recently, music industry. When the 3 main music labels rights holders sued, some music generative AIs, right? And then, before that, New York Times and multiple news. Then there's the Sarah Silverman, the authors. There's the video. So all these different content creators have sued OpenAI, ChatGPT, Microsoft, whoever the big players are. The issue is the fact that I don't think there's any doubt whatsoever, and basically it's all been admitted. Every one of these AI engines for their large language model to train has gone out and accessed copyrighted works. Whether they've had to.
They've had to. There's no question.
Nobody's really even arguing that they haven't, right? And often accessing stuff that they, through torrent sites and others, they didn't even have the right to get to. That's another issue. But no question that they've accessed and consumed and digested to train. We were talking about fair use earlier. Prior to AI is a little bit different, and that's where the challenges are. But there's a body of case law that would automatically sort of start. And where I first started thinking about this, it's like, well, that's fair use. Because one of the factors of fair use is what is my use compared to the original. Well, the original was out there to inform or to entertain or whatever, to create, I'm not informing, I'm not entertaining, I'm not doing any of those things. I'm learning, I'm training someone else. I'm training a baby how to talk, right? That's a totally different use. Plus, you can't point to any one output and says this output is a copy of that piece of work. So you're like, well, that's sort of fair use. Traditionally, it's a totally transformative use. But
Hmm.
where it's interesting is the arguments that are getting stronger and stronger, I think, particularly in the music and in the news world, is the last factor. Remember, I said fair use has four factors. We talked about minimal
Yep.
use and all that. The last one is, does the new use negatively impact the commercial value of the original? And so if there is no thing, one to one, it's hard to say that an AI reduces the commercial value of an autobiography written by somebody. I want to go read that book. But in the news world, in the music world, what the arguments are being made is, if ChatGPT can go and scrape everything from the New York Times and everything else, well, and then I can just ask, hey, ChatGPT, what's the latest headlines or what's the latest news about this, and it spits it out. Well, then I don't have to go pay New York Times subscription. I don't have to. I am, in fact, negatively impacting the economic value of their original news reporting. Music, if AI, if I can say, hey, I got this video I'm putting together for, my client brand. And normally I'd have to go pay thousands of dollars to use this song by, the Black Crowes or pick whoever. Well, if I can just say, hey, AI, make me a song that sounds kind of like them. Well, that new song doesn't infringe the original, but it takes away any, if I can basically copy any artist functionally, well, I may, the biggest amount of money that artists often make is from sync licenses, things like that. It literally undercuts. Or maybe I don't have to listen to them on Spotify. The other thing is the AI in the music world is flooding the streaming services. I
Yeah.
go on Spotify, I go on, YouTube Music or whatever your favorite, default streaming app is. And I put in a playlist, I use YouTube Music as sort of my default because I have a YouTube premium account for my own videos and stuff. So I'm like,
Yeah.
oh, great. This works. I like it. It's like everything else. Pops up. Oh, I'm sitting outside today. Oh, it's my super mix. It's going to make a mix for me. And it's going to start with stuff I recognize. After a while, it's background. I could have 3 or 4 songs in there. I don't know who that is. I don't know if that's AI. But suddenly there's artists that are not getting the streaming revenue that they would otherwise get. And so the arguments that are being made, lawsuits are getting filed, not daily, but close, right?
Yeah.
But they're still early in the filing. I think what we're going to see, I think maybe this year we may see the beginnings of some rulings, but every one of these cases is going to turn on what fair use means. And until the courts have ruled on what fair use means in this context, or where the limits are, the guidelines
Or
are.
legislation.
Well, exactly. So typically what will happen is the courts will rule in a way that people don't like, or people will be afraid that the courts are going to rule a certain way. And so a combination of either legislation, which moves very slowly, or more likely business is going to start to adapt. So in the music space, there are certain AI engines that enter into license agreements for music. They just, no, I'd rather license it. Social media platforms, TikTok was the first one. Get around the music thing. It just made a deal with the rights holders. It pays money. And then if I go on TikTok, I can select any one of these songs and it's already granted for me. So the businesses adapt, I think, faster than the courts. But if you go back to like file sharing in music, Napster, Grokster cases 20 years ago, people first were sharing files. The courts, when they said that's copyright infringement, well, what we got out of that was iTunes. iTunes, when Apple, people said, people aren't going to buy a song for 99 cents. That's great, whatever. But what we learned from those things isn't that people want to steal or people want to infringe, but now we know people want to get their music on these devices. People want to get their music in this way. So let's sell it to them in a bite-sized thing. And all of a sudden, we now have, we went from iTunes to 1 million different streaming platforms because of how the law worked on those. And then we get the Digital Millennium Copyright Act. Act, which is now an old statute. But that came out of those cases that said, okay, YouTube, whomever else, you are not guilty for infringement if, when someone else uploads infringing material to you,
Yeah.
if you have a notice and takedown process. So if the copyright owner can say, that's my stuff, I can get it, take it down, then you get a safe harbor and you're not guilty. And what it said was, we're not going to make it you, and rights holders said, well, YouTube should have to police that. And the court said, that's unworkable. No, we're going to have a mechanism for you to watch your own material. And if you see your material up there, then you can take it down. People say, well, how are we ever going to find all our material? There's so many things. Within a year, we had, software to tag
that
your
would
stuff.
listen and
Right. So the industry reacts, and the technologies, software figures out what rights are, who's responsible for this, what's going to make it possible. So I think that's where we're going to get to. But it's going to probably start by the first court ruling that weighs in on fair use. And it'll probably be a district court. It'll have to then go to a court of appeals, may even end up in the Supreme Court. But you might see Congress act before it gets that far, if it can read the tea leaves. So it'll be interesting to watch.
I'm not sure Congress has some other problems or has some other age issues, maybe, to really understand some nuance of AI and fair use.
Well, right. And yet there's a lot of pressure. Maybe. Well, there's still a lot of pressure on legislatures to take some kind of action. And so we'll see. You got an awful lot of money on both sides of the issue, which means money to pay lobbyists, which means you could see some legislation eventually, even if it's just around the edges, to start to, know. And typically what starts to happen is once the businesses involved can see sort of where things are going, then they'll structure their business deals to stay just on the right side of it and maximize the money they can make. If you read some of the news quotes from investors in the music AI companies and things like that, they're like, we know we're going to get sued. Part of what they're doing is testing right now, so they'll know what to do next.
Yeah.
As
a strategy.
I would imagine that on most of the, you put the pitch deck for the potential investors, give me $1 gazillion for this. Somewhere in the use of funds category is litigation.
Oh, yeah.
It's just expected, right? This is part of the process that we go through with new technology and new creative content, that it's going to take a little while to figure out where the rights. But copyright law hasn't changed. Contract law hasn't changed. So we got to fit in those things.
What about name, image, and likeness, like Scarlett Johansson's, I believe, had a lawsuit, or at least a very public fight with OpenAI. Is NIL have a different set of view on AI?
Not really. I mean, so what her claim was about, the voice, the most recent version came out with there was voice activated, had a voice response. Yeah. And of course, she was in the movie Her, and her character was, was that voice, right? And Scarlett Johansson has a very distinct, recognizable voice. And they were in negotiations with her. They literally, said, hey, we'd like to use your voice. She even thought about it for a while and decided ultimately no. They did it anyway. They released it in the beta. And she's like, wait, so they're very public complaints. They took it down and all this stuff. But I think she was absolutely right, because that was an example back to the influencer, world. Mm-hmm. The name, image, and likeness, we think of that as, well, name, image, likeness, copies of your face, versions of your face. It's really, what it really is shorthanded for is identity. And a lot of people's voice, my name, my image, my likeness, I can say that's me. But if you
your
took
salmon shirt and your blue glasses,
exactly. But if you take the video away, you just put my voice, I don't probably have a publicly recognizable voice. So not every public figure has a voice only public identity, but some people do. And the courts for years have recognized it. Bette Midler, Tom Waits, both were successful in lawsuits where they refused to do the advertising. So the advertising agency or the brand together hired a sound-alike and let people think that that was, and everybody thought it was them. And they sued and they won because they said, wait a second, you can't use my identity, my voice only, to sell your product, which is what OpenAI was trying to do with Scarlett Johansson's voice. So that I think was absolutely the right thing. She was absolutely correct. But what about actors? I can use AI now to put, this dead actor and with this dead actor or this live actor and put them in a different thing. There's challenges there.
Well, and it's even more nuanced because like AI could help edit this podcast, and if you hit the microphone in the middle of a sentence, AI could go and just kind of clean it up a little bit without necessarily, changing the whole 60 minutes of what we have in there. So that's
fine.
Weird,
there's no problem with that kind of thing because using AI as a tool is no different than, Photoshop or any other audio.
Correct.
I'm doing my mixing levels. That's not. That's just using an existing technology tool that will make a product better. What we're talking about is the ability to not have me on, but generate a version of me, and in such a way that people think it's me or whatever, right? And I'm not a public figure, so it's not so much an issue. But the point is, this can be done for public figures. In the actors' strike last year, SAG-AFTRA strike, one of the issues for the rank and file actors, not necessarily the main stars who typically sign their own deals, but for everybody else that's governed by the standard 3-year SAG-AFTRA contract, they were concerned that extras would essentially show up one day and then be digitized functionally and then
not be needed ever
now
again.
You're in a Civil War movie. Now you're walking down the street and 2200 on the moon or whatever because we don't need you. And so residuals and extra money. So there's a lot of concern about how he's going to do this. In the writers' strike, they actually, in the contract that they finally signed, there's specific language that says AI cannot be used to reduce the writer's share, right? All works has to be, the result of human authorship. That's copyright law. Films have to have a copyright owner. If an AI engine wrote the script, there's no copyright in the script. Anybody could do the same movie, and the film couldn't stop them. So the studios had an incentive under copyright law to limit the use of AI. But what the writers were afraid of, is they say, well, you didn't write, because under that contract, if I write all of it or if I write part of it, it affects my pay, it affects my credits, all these things. If I'm a writer and you give me a book, then there's source material and then it's my writing. I get less than if I wrote everything because it's based on source material. What the new contract says is the studio can't use ChatGPT, for example, to write a whole script, call it source material, hand it to you to write. It can do that. But if it does that, this writer gets a full share. Yeah. So basically, the contract says AI can't be used to reduce the role of humans or reduce their pay. That was a big, big deal in that contract. Actors got some things, really long time. I mean, we're watching shows now a year later than we would have watched them because of last year. But AI was a huge part.
But the lawyers got paid for a lot longer of retainers. So
well, I'm in the wrong part of there's all the collective bargaining attorneys for sure. But those because more than ever before, those contracts are 3-year contracts. 3 years earlier, AI wasn't on anybody's radar.
Sure.
Now it's everywhere. So it's really going to be interesting to see how the courts deal with this in the next 6 to 12 months and where we go. But, I think it's real. The Copyright Office made it very clear. If you use too much AI to generate something, you may lose a copyright in it, period. And if owning a copyright is important to your business, like we talked earlier, then be very careful. So we're starting to see contracts now that expressly state, you've seen these, Ryan. So the contract will say, let's say you hire me to produce, some videos for you. Somewhere
Hmm.
in there probably is a representation of warranty that I'm going to make that says everything I produce for you is original. I didn't infringe anybody else's work, and I own all the rights, and I can give them all to you, and you will be the owner of the copyright in everything here. Okay? And we just say, oh, yes, of course, check, 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 check. Never think about it. Never read closely because I know that. Sign it every time. But if then I turn around and I use generative AI to save myself a bunch of steps and do all the animation while I do all this, guess what? The animation is everybody's because the
Yep.
copyright said no human authorship, no copyright at all, which means public domain. So now that contract, I'm breaching it the moment I deliver this to you. And the brand or whoever hired me doesn't actually own the copyright in those works for whatever part I didn't use or that I used too much AI in. So now we're changing those contracts and little adding
Mm.
in, and is not the use of too much AI, is all substantial human authorship, simply to remind everybody. And again, this gets back to the world of copyright law is going to work a certain way. If you want it to work differently than it's going to work automatically, you'd simply need to write it in the contract. And so it becomes, we get back always in this area. Look, we don't know what exactly AI is going to come out here. So between these two contracting parties, let's decide how we're going to deal with it and what promises we're
Hmm.
going to make to each other. That's always the safest way to approach these things.
So I have two more questions,
Sure.
and I know we're coming up on time. Um, but I wanted to give you a chance to talk about some of the memorable cases that you have been involved in. I know I do listen to your podcast, and I know there was a really interesting one with a tattoo,
Yeah. Yeah.
perhaps. But if you want to tell a different story,
Well,
more than welcome.
I
But
can, sure. always having fun. So, I kind of got into the world I am now. My sort of, I describe my practice as a screen lawyer. I work the things that get on screen, but I got into this world first litigating over those things. So this image behind me, and if you're on audio, what it is, it's a poster that's a blown up frame from a Spawn comic, issue number 6 of the original Todd McFarlane Spawn comics. And that character is Antonio Twistelli, AKA Tony Twist. Well, back in 1989, no, 99, something like that, not 89,
yeah.
but 99, Tony Twist, the hockey player for the St. Louis Blues, sued Image Comics, Todd McFarlane, a whole bunch of other people, HBO, because there were 3 seasons of Spawn animation by then, over the use of his name in the comic book. And so I was part of the team that represented Image Comics and Todd McFarlane. And that case went on for 8 years, up and down courts, Supreme Courts, new rulings, all sorts of stuff over when can you use what constitutes commercial speech, because it was inside this, but the argument was made, yes, but you used famous hockey players' names, which Todd admitted doing, to make the comics more attractive. And that was how the law ended up coming out. So that was one where I first got cut my teeth. And at the time, my wife was a nurse, and she used to say, well, I can't tell people my husband's a lawyer because everywhere in the hospital, like, oh, lawyers are, scary. And she's like, no, 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 no. He doesn't sue hospitals. He's a comic book lawyer. Like, okay, good. So that was my thing.
Yeah.
And then years later, the one you were talking about, the tattoo. We represented Victor Whitmill, who is the tattoo artist who put the tribal tattoo on boxer Mike Tyson's face, arguably one of the most famous tattoos in the world. And
From Missouri, he got his tattoo
well,
in rural
no,
Missouri
he
too. Which
he
is
actually no, he didn't. He got his tattoo in Las Vegas, but
cool.
after a number of years later, the tattoo artist moved from Vegas to rural Missouri, like relocated, got out of the Vegas lifestyle, was in small town, kind of down near Rolla, Missouri. Very happy, had a tattoo parlor, very much a part of the community, just a great guy, right? He walks into 7-Eleven and sees a big gulp with Ed Helms' face on it with that tattoo. He's like, wait a second. That seems like they should have had to ask me or something, right? So a local lawyer that he talked to had taken a copyright class in law school from my partner. We ended up with the case and we sued Warner Brothers because Hangover Part 2 was getting ready to launch. And everywhere the advertisement was Ed Helms' face with the tattoo. So they were using this copyrighted work, the tattoo, not only in the movie, but to sell the movie. And we sued and said that's copyright infringement. And they tried to argue, well, no, we got a license from Mike Tyson. Mike Tyson got an implied license when he put the tattoo on his face. Mike Tyson can go anywhere in the world, be filmed, photographed, whatever. Mike Tyson can go into business with likenesses of his face in a logo with the tattoo because it's Mike Tyson. That implied license went from the tattoo artist to Mike. But the moment someone copied it and took it off Mike Tyson and put it somewhere else, that's copyright infringement. And Warner Brothers had over 6,000 copyrights at the time, but missed this one. And this is an example I sometimes give to even small clients. Look, there's so many layers of rights in these things. You can't just assume, oh, we got this, so we got that. No, there was another layer there that they just missed. And it was a fascinating case. We had a crazy 3-day preliminary injunction hearing right before Memorial Day weekend. Ultimately, the court ruled that we were correct. This was infringement, but it wouldn't shut down the movie because there was over 3,000 movie theaters around the country that were getting ready to have this tentpole movie open up and pay for their whole summer. And they were innocent, right? And so in the public interest did not warrant an injunction to stop the movie. But effectively, we persuaded the court that we were correct. And, later that summer, we got a nice settlement for Victor. And so that turned out well. But it was a fascinating case, tons of press. Only time I've ever been involved in a case where, on a Sunday morning before the hearing, like the Today Show is talking about it with their legal experts about whether copyrights are whether tattoos are copyrightable. It was pretty cool. So occasionally some fun, interesting sort of entertainment-based, copyright-based lawsuits that found their way to St. Louis, and we got involved in them, and we sort of became, I guess, in some weird way, the go-to for some of these cases, and that led me into the other stuff that I do now.
Well, I'll put that episode in the show notes for anybody that's interested. I thought it was a fascinating case.
Yeah.
And when I was listening to it, this is a small aside, I'm amazed that you don't say or at all. I'm actually very much looking forward to editing this because maybe that's just the trial lawyer in you. You have. How do you get that out of your vernacular?
I honestly don't know. I'm going to start saying a bunch now because you just said that. So
don't do it. Don't do it.
Lots of practice, I think.
One more question. What is something you've changed your mind about since you started your career?
Wow. That's a really interesting question. Well, one thing I will say is I changed my mind. I thought I wanted to be a trial lawyer and a litigator. And I was for the first dozen years or so of my career. That's why we were doing the Victor Whitmill case, the Spawn case. But where my mind changed was I think I realized that I would be more valuable and have more fun helping people avoid trial in this creative space, right? And so I still play music in a classic rock cover band. I was a cartoonist. I wanted to have a career in the creative spaces, but never really, frankly, didn't have the talent or whatever the fortune to make a living being in that space. By coming back around and realizing instead of only getting hired when there's a lawsuit, but instead helping people at the apex of their, or at the beginning of their creativity all the way through the apex, I could hang around with those creative people, be part of that process at a professional value level, and therefore still get to sort of scratch all those creative issues I had. And I realized I liked that. And I didn't think that at all when I started my career. It probably took 15 years to get to that point. And that's just been continually reinforced. So now I really enjoy the education part of this. This is a great conversation, Ryan, because I'm happy to share these thoughts. I think they're important for people to know as creators. If they get to the point that they want to hire me, terrific. But if they know this stuff going in, they're going to be a lot more effective and more likely to be the kind of clients that we want to have a relationship with over a long period of time. So for me, I think that's probably the biggest thing that's changed is my view of where I want to be involved as opposed to fighting over other issues.
I maybe I'm putting words in a lot of lawyers' mouth, but I bet litigation is kind of a younger person's game a little bit. Like, I'm sure there's this like stress and emotion and like excitement about getting up on the big stage. I can think about that like with my poker career. That was just so exciting to be able to do that. But at some point, you get a little bit older and you realize the wisdom in preventative care, I guess, right?
Yeah, certainly.
And maybe taking the foot off the gas. I'm probably wrong about this in some ways, but
No, I think that's an interesting point, and there's some aspect of that to me. Certainly, I mean, I remember, when I went from being an associate, one of multiple lawyers at the table, to being the first chair and having other associates and people looking at me to make all the decisions. I would, I frequently would, throw up a little bit in the courthouse bathroom before we got started every time, just because
yeah,
it was,
yeah.
But that was also part of the adrenaline. That was like the big game. But I know, we've got partners in my firm that are more senior lawyers than I am who are still trial lawyers and love it and are very, very good at it. But they're typically not the kind that are in for the kill, right? They understand litigation is important, but it's always about the value to the client, making sure the right outcome happens. But I would imagine there is some of that. For me, it probably had something to do with me maturing and realizing what I wanted. If I wanted to do something for a long time, I had an itch to get involved on the make something happen side as opposed to clean up the pieces side. And that's just where I gravitated to. So some of it was maturity, which sometimes comes with age, for sure. I put in just as many hours sometimes now in this other work, but it doesn't feel the same way from a stress thing of, preparing for a deposition or preparing for trial. It's a little bit different animal. But I think lawyers are all, our litigation partners are not only young and just that's what they're really good at it and that's what they enjoy. I don't think age is automatically a thing, but for some of us it might be.
Just in general, the profession, I think, when I was growing up, for some reason, had a bad rap, like the lawyers just taking cash or whatever. But like that's changed, right? Like, and I think you see because of how critical the legal mind is. I mean, how many CEOs have a JD? Like,
Yeah.
it's not just in trial lawyers. There's so much that very analytical way of thinking. I don't think what your wife said about lawyers being allergic in the nursing floor is quite as prevalent today, and I think that's a good thing.
Yeah,
So,
maybe that's true. One of the things I like to tell people in the creative space is don't be afraid of the lawyers. Don't be afraid of contracts. But if you are, or you're uncertain or whatever, that's because we haven't done a good enough job to get you comfortable that this is how it all works. And so when I'll go to like classes at Webster or Lindenwood that have film programs and talk to the students and say, look, this is all governed by copyright law. It's all governed by contracts. Don't be afraid of it. Don't let someone tell you, oh, you don't need a contract. It's all good. And you're afraid to say no. No, it's part of the world. It's part of the business. Work it into your budget. Look at it as just as important as the cameraman or the editor or whatever, and understand how it works. Then you're not afraid of the contracts. Then you can actually get something on screen. So some of it is just education.
and have a base knowledge of those things. Creatives, for instance, need to have a base knowledge of digital analytics now to
Sure,
be able
of
to do
course.
their job well. They need to have a base knowledge of contracts. They need to know what indemnification is.
Sure.
Like it's not like you don't have to become an expert, but you should be able to kind of know what you're reading and what you're signing. Even just the public in general doesn't know when they sign into Facebook what rights they're giving away.
Totally.
And
Totally.
they have made that contract 85 pages long and
Right.
impossible to a
Right.
point where I think that they get sued because of how
Right.
verbose the
Right.
those end user agreements are. But we're past time. I want to be respectful.
Sure. Oh,
So
this has been
thank
great.
you, Pete.
Yeah, my pleasure. This has been a lot of fun.
This is a lot of fun. Thanks again, Pete. This has been a great conversation, really useful. Hopefully, my audience listens from start to finish too, because this is great baseline advice. I think for a lot of marketing professionals, creatives, to start to think about a number of areas that they need to be paying attention to safeguard their business.
My pleasure, Ryan. It's always a pleasure to catch up, and thanks for being my guest a couple months ago. So I'm happy to return the favor, and I really appreciate it. I'm happy to talk anytime, and I enjoyed it.
Absolutely. Thanks, Pete. I will see you at the Evolution Music Fest in the VIP section, I'm pretty sure.
I'm hoping so. Right on.
Yep. I'll see you there.
Sounds good, Ryan. Take it easy.